Hello, everyone, and good afternoon. My name is Kiowa Hammonds, and I am the Rights Clearance Manager at the New York Public Library. Just to give a little bit of background, I manage basically everything that has to do with copyright at some level of our collections at New York Public Library. So that involves researching rights holders within our collections. It's also managing a team of digitization coordinators whose main job is to facilitate collection-driven projects. So when some of our librarians or curators need things digitized for some kind of online use or for print materials, then my coordinators and I help facilitate that. And that includes a lot to do with rights, making sure that we have permissions or doing active clearance. Myself and my team are also responsible for rights metadata implementation. Rights metadata for us is a kind of our record of rights clearances, copyright notices, licenses that may be acquired, and provenance and collection materials. As I'm sure a lot of you know, when we get collections for research branches, a lot of times there are stipulations or allowances within those acquisition paperwork. It's very valuable for the library as an institution to know what it can use. And so a part of myself and my team's job is making sure that that stuff's documented and we have access to knowing about it every time we forget it. I also advise staff on copyright related questions and policies that have been drafted with my department as well as our legal department. I also draft and review contracts and licenses related to copyright and rights related issues having to do with exhibitions and publications. And I'm also currently, in at least the interim, managing our permissions department, which handles third-party requests. So a lot under my hat, but I love talking about copyright. And so I'm hoping you all get some benefits of this. Okay, the title of the series is Copy That. It's a 3-part series of copyright basics. Part 1 is what is copyright and why, copyright duration, and international treaties. So again, today the potpourri is going to be what is copyright and why, what is and isn't copyrightable and exclusive rights, the ownership of copyrights, copyright duration and the public domain, and a little bit about international treaties and how they affect US copyright law. Just to give a little preview, part 2 of the series will be focusing on exceptions and limitations in US copyright law. That includes fair use, first sale doctrine, and Section 108. And in part 3, we're going to focus on licensing and how that applies to libraries, as well as information about how digitization projects and access to digital files within a library and outside. So that's going to be in part 2 and part 3 of the series in the coming months. So unfortunately, before I go any further, I have to give a bit of a disclaimer. Nothing you hear today should be construed as legal advice. This information is given for legal education purposes only. It may not work for your specific situation. And if you'd like legal advice for your particular situation, I suggest you engage with legal counsel. Nothing the presenter says today should be attributed to a particular client. So just some food for thought on everything we're talking about today. With that in mind, let's get started. What is copyright and why? To give a brief history, US copyright origins arguably began with the advent of the printing press in England in the 15th century. As many publications came into favor, the idea of controlling the newfound commerce came with it, culminating with the Licensing Act of 1662, which granted licensing rights to the publisher. Now in 1710, the Statute of Anne was enacted by Parliament, which granted rights to the authors of works for a term of 14 years. The statute states it as an act for the encouragement of learning by vesting the copies of printed books in the authors or purchasers of such copies during the times therein mentioned. Now, this statute originally only applied to books, but later expanded to other creative content. With US independence, of course, from England in 1776, the subsequent laws forming the US Constitution naturally took ideas from England, though I'd like to add that was not considered an infringement of copyright. And this led to the enactment of our own regulation of ownership of intellectual property in 1787 under Article 1, Clause 8 of the Constitution. Now, copyright in the US has some similarities and differences to copyright in other countries, and there are also treaties that unite the US with other policies internationally. And we're going to come back to that later in this program. The first federal Copyright Act was the Copyright Act of 1790, which allotted protections for works for a term of 14 years, much like the statute at Anne did for England. The first copyright case was Wheaton v. Peters, which was reviewed by the Supreme Court about 40 years after this law was enacted in 1834. And ironically, this first case was between two court reporters for the Supreme Court and the copyrightability in their written opinions that were delivered by the court. Basically, both parties were court reporters, and one was maybe lifting some of the information and thoughts from the other reporter, and so there was a lawsuit involved. Now, major revisions to the Copyright Act came in 1909, which was about 119 years after the establishment of copyright protections in the US. The 1909 Act further established federal statutory copyright protections for original works. And here I'd like to quote Theodore Roosevelt in speaking about the need for revisions that led to the 1909 Act. And I'm going to give this quote mainly because I think it sums up the justification for all revisions to copyright law that we've seen. And I quote, "Our copyright laws urgently need revision. They are imperfect in definition, confused and inconsistent in expression. They omit provisions for many articles which under modern reproductive processes are entitled to protection. They impose hardships upon the copyright proprietor which are not essential to the fair protection of the public. They are difficult for the courts to interpret and impossible for the Copyright Office to administer with satisfaction to the public." So the 1909 Act also broadened the scope of what types of works were protected and extended the duration of protections for published works to 28 years from that original 14. And this also included an option to renew copyright with the US Copyright Office, which would give a copyright holder an additional 28 years of protections. Now, at this time, unpublished works were left to state laws primarily for protections. They were not covered by federal law at that time. Further revisions to the Copyright Act came again in 1976. And this time it was primarily to address advancements in technology, since if you think about it, during the period between 1909 and the 70s, the advent of television, motion pictures, new methods of sound recording, and radio were all new forms of intellectual property that were needing protections. The 76 Act also created an alignment of US copyright law with those of the Berne Convention, an international copyright treaty that the US signed to eventually in 1988, and we will get to in more detail at the end of this program. The 1976 revision further defined exclusive rights and defenses and remedies for infringement. They also codified the doctrine of fair use and established exceptions for cultural institutions like libraries. They also adopted a unitary term based on the date of the author's death rather than the prior scheme of fixed initial and renewed terms. This was addressing both published and unpublished works under federal protections. Again, in the 1909 Act, unpublished materials were not covered under US federal copyright law. Now, this act also included additional types of works protected, such as choreographed works, and perhaps most crucially, extended copyright duration to 50 years. And we'll be digging much deeper into that later in this presentation, and when we talk about limitations and exceptions in part 2. So, with a bit of history under our belt, we can jump back to the beginning. Article 1, Clause 8 of the Constitution. This is where the heart of copyright lies. The copyright law, I mean. And I'll read the quote here. "The Congress shall have power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries." So let's deconstruct this a bit. Copyright, on the one hand, serves to grant and protect one's exclusive rights to their work, but that limited timeline also holds a lot of significance here. I'm talking about here a balance within copyright law. Protection for creators, allowing exclusive rights to their works, but also ways to incentivize other creators to make work by setting terms and a duration to those protections in order to incentivize further creativity and economic gains by other citizens. And that's where we get copyright terms and the public domain, which we'll be getting into in more detail in a moment. Now, currently, the Copyright Office of the Library of Congress is responsible for overseeing the administrative functions of copyright law. Congress enacts copyright laws, and the federal courts interpret and enforce copyright law. With some history under our belt, we can ask what is and isn't copyrightable, as well as give some information about exclusive rights. Section 102A states that copyright protection subsists in accordance with this title in original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or indirectly with the aid of a machine or device. So here it's the concept of fixation, physical creation in a recognized and tangible medium. Now, what mediums, you might ask, are under this definition? These include literary works, musical works, including any accompanying words, dramatic works, including any accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. So here's a little montage of some of those examples here. Now, what are some things that aren't copyrightable, you might ask? According to section 102B, things such as ideas, procedures, processes, systems, methods of operation, concepts, principles, or discoveries. This is regardless of the form in which these are described, explained, or illustrated, or embodied in such a work. On the one hand, we have fixation versus conceptual. There needs to be a tangible element to a creative work besides an idea floating in the ether. And we're also talking here about expression versus fact. If a work expresses some creative characteristics beyond factual information, then that work has the potential to be copyrightable. And I'd like to point out that many copyright cases include interpretations of 102A and 102B of what is and isn't considered copyrightable as part of their arguments. And I'd like to go over a couple with you right now. The first example is of the courts determining fixation and expression can be found in the 1991 Supreme Court decision on Feist Publications, Inc. versus Rural Television Service Company. Here, the court's decision weighed heavily on whether factual information or the compilations that collected them are indeed copyrightable. As Sandra Day O'Connor wrote in her opinion, many compilations consist of nothing but raw data, i.e., wholly factual information not accompanied by any original expression. On what basis may one claim a copyright upon such work? Common sense tells us that 100% uncopyrightable facts do not magically change their status when gathered together in one place. The key to resolving the tension lies in understanding why facts are not copyrightable. The sine qua non of copyright is originality. Now, the court further ruled that intent of copyright law cannot be given simply by reward of effort. This is something in the courts they call the sweat of the brow doctrine. The idea here is that no matter how much work it takes to put together a directory like a telephone book, the fact that the information is primarily facts means that it's regardless of the work put into it, it is not indeed copyrightable because it doesn't have a level of creative expression that meets the bar for the courts. So another example I'll give about 102A and 102B is the Google v. Oracle case, in which the company Oracle claimed to own copyrights in certain aspects of its Java software platform that Google implemented in their Android phones without taking out a license. Now, under 102A, copyright protection extends to original works of authorship, and under 101, which describes definitions, it is expressly listing computer programs among the types of works of authorship that can be protected. But per 102B, copyright does not extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery. So if those elements are embodied in the work. So here, Google argued a difference between what they call declaring code, which tells a computer what to do, from implementing code, which is the computer code that performs the task stated to the declaring code. So the difference here being that implementing code has attributes of expression in its instruction of telling computers the different actions they need to do. But declaring code is not, because it is a method of operation, fact, and not expression. And the case was actually resolved fairly recently in late 2021 by the Supreme Court. And the idea of that declaring code is not expressive, but indeed factual, helped support Google's fair use argument in the case. So they eventually won that case based on fair use. With that in mind of what is and isn't copyrightable, we can talk about the bennies, the benefits that one gets when they are a copyright holder. That is called exclusive rights. Now, exclusive rights for a copyright holder includes the right exclusively to make copies of their work, which is perhaps the most important of the rights granted, since most copyright infringement cases revolve around copying disputes. You can also distribute the work, which is a control of how a work is transferred to others, whether by sale, rental, lease, or lending, as well as to prevent the distribution of unauthorized, i.e. infringing copies of a work being distributed. You also have the exclusive right to perform the work in public. And a performance is considered public when the work is performed in a place that's open to the public, performed at a place where a substantial number of persons outside of a normal circle or family and its social acquaintances are gathered, or it is transmitted to multiple locations. And this mainly applies to things like literary works, music works, dramatic works, choreographic works, etc. You also have the exclusive right to display the work in public. And again, a display is considered public when that work is displayed in an open place to a substantial number of people and is transmitted in multiple locations. So display and performance are sort of similar, but depending on the medium we're talking about, that comes into an important distinction. I'd also like to point out that exclusive rights include, specifically for performance and display in the case of sound recordings, an exclusive right to perform that copyright work publicly by means of a digital audio transmission. So the ability to broadcast, to stream, etc. And finally, you have the exclusive rights to make derivative works based on the original work. This means make transformative uses of the work, such as annotating, editing, translating, modifying, or making other types of changes to that work. And I do want to point out that transformative here is a key word that is also used heavily in fair use arguments. And there's a slight distinction there that we will get into in part 2. But for now, just knowing exclusive rights here means the derivative is the ability to make transformative uses. So now that we have a bit of understanding about the exclusive rights you get from copyright, let's see who gets those exclusive rights, which is the ownership of copyrights. This is my first example. This is a photograph by the surrealist André Chanté titled Dog in Hat, which is hanging at the Museum of Modern Art here in New York. Now, does the Museum of Modern Art own the copyright now that it owns the photograph? The answer is no. Physical ownership does not equal copyright ownership. Unless the copyright to a work is transferred to the owner by the copyright holder, it is the artist that owns the intellectual property rights to that work. So in this case, it would be the André Chanté estate. Here's another example. This is Neil Gaiman. He's an English author and all-around goth icon. And here he is at his desk writing a letter. Now, who owns the copyright in the work that he is writing? Does the copyright go to the writer of the letter or the receiver of that letter who would eventually own it? Under Section 201 of US copyright law, copyright in a work protected under this title vests initially in the author or authors of that work. So here it's Neil Gaiman as the author of the letter that retains the copyright and not who eventually receives it. Now, let's say Neil Gaiman and best-selling fantasy author and long-lost member of Fleetwood Mac, Terry Pratchett, write a book together called Good Omens, which they did. Now, who owns the copyright in which works? Under 201, called a joint work, is a work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. So here in this case, both Gaiman and Pratchett duly own the copyright to this work. What if we have multiple authors who are contributing essays, articles, or stories in a book? The intention here is not to merge them into inseparable parts. Under 201C, contributions to collective works, copyright in each separate contribution to a collective work is distinct from copyright in the collective work as a whole and vests initially in the author of the contribution. So what that means is that each of the authors who wrote short stories that are collected in this book, Legends 2, which included Neil Gaiman and Terry Pratchett, each of those authors retain the copyright for the works that they created. Now, it is a little confusing. I'll point out that, sometimes when you see an anthology like this, you may see a copyright notice that is to the publisher or to the book, to the title of the book itself. What that is kind of covering is not necessarily the stories, but the introduction, the afterwards, and other elements that stand outside the short stories. But again, unless the authors themselves transferred rights in some way to the publisher or another entity, they retain the copyright to their individual works that are collected in this anthology. What if Neil is writing a memo on behalf of his company? This is what we call a works made for hire. In the case of a work made for hire, the employer or other person for whom the work was prepared is considered the author for the purposes of this title and owns all of the rights comprised in that copyright. So in section 101, works for hire arrangements, it's determined by a few different factors. One is a work prepared by an employee within the scope of his or her employment. So, a lot of times when you get a job, you might see a work for hire or intellectual property clause in your contract to take on the job. It's something that states basically that anything you are creating while working during work hours is the property of the company you are getting the job with. And that extends to intellectual property. So going back to the example of Gaiman, if he was writing that letter or that short story while being on the job at his job at Sony, it may be Sony that retains that copyright and not him, even though he's the one that authored it. Another example for a work for hire arrangement is when a work is specifically ordered or commissioned for use as a contribution to a collective work, or as part of a motion picture or other audiovisual work, as a translation, or as a supplementary work. So basically, Neil Gaiman in this case would be hired specifically to write that short story for this book. And the difference between that and, say, the anthology example I was giving is that in the contract that Neil Gaiman is signing, it also states that the company or publisher that is hiring him to do it will retain that right. So therefore, he becomes a work for hire. It's the employer who is considered the copyright owner and even the author in some cases, and not the person that actually penned it. It's also important to keep in mind that many copyrights have different layers of copyright within them. So for example, in music, there are usually at least two copyright holders involved. First, in the composition, which is usually the composer or company that commissioned the composition. And that's the composition underlying the performance. And second, in the sound recording. So the sound recording is when it's recorded, there may be rights holders with the record company, the distributor, or even the musicians that are playing the music. So at least two copyright holders in a lot of recorded music. Now, a film may have protections for the underlying script, the music, the production, and even the costumes or scenery if those have trademarkable elements to them. It's also important to know that, like personal property, copyright can be transferred to others. Under Section 204A, a transfer of copyright ownership other than by operation of law is not valid unless an instrument of conveyance, i.e. a contract of some sort, or a note or memorandum of the transfer is in writing and signed by the owner of the rights conveyed in such owner's duly authorized agent. So in this case, copyright can be transferred by means of a conveyance or operation of law. The best example I can give here would be in your will. You can transfer your intellectual property rights to a work that you created just as much as you could transfer the physical property. So many estates of artists may transfer in their will the rights to their intellectual property rights to their work to different parties, whether it's family or to a foundation or trust, etc. That's irregardless of if the physical painting or what have you is owned by another entity. So Andre Chante may have willed his rights to me for that painting that is held in MoMA. So MoMA gets the physical painting, but I control the intellectual property right, those exclusive rights to that painting. It's also important to note that these rights can also be transferred to an institution or company, such as a library or museum that owns the physical work. New York Public Library has thousands of different collections, and we also, to some of those, have also the intellectual property rights, the copyright to those collections. That's usually been transferred to us through a deed of gift or other forms of agreements after the acquisition. And again, that's where it's really important to have at least legal teams or other people that can identify that. You may not know what copyright you might hold in the collections that you may physically own. With that in mind, of who owns copyright, we can get into how long do you own copyright, copyright duration, and the public domain. So, currently, under the 1976 Copyright Act, works created after January 1st, 1978 are protected for the life of the author plus 70 years. For anonymous works or pseudonymous works or work made for hire, copyright endures for a term of 95 years from the year of its first publication or 120 years from its creation if it wasn't published, whichever expires first. So what that means is that anything we are creating today, the tweet you might have put out this morning, the Instagram post, the novel that you're getting published, the art piece that you're making, as soon as it fits the criteria of fixed and intangible medium and of creative expression, you automatically have a copyright to that work for the duration of your life plus 70 years. Now, also under the 1976 Act, all works created or published after March 1st, 1989 no longer require a copyright notice. Copyright registration is also no longer required. But with that said, there are still a lot of incentives for registering your work with the Copyright Office. The main one being that you're entitled to more statutory damages and compensation if an infringement case is filed and you win. And it's also having a copyright notice helps to clarify who the copyright holder is. But again, currently, all that stuff that I mentioned, painting, tweets, books, what have you that you might have made, you don't need to affix a copyright notice or publish it even to have protections for that work. And we will be getting into more incentives and how to register works if you decide to register your copyrighted works in part 3 of this series. What about works created before 1978? And 78 is being used as a date here because the 1976 Act, even though it was established in 76, took a couple of years to mark when these changes of life plus 70 years were going to start. So works created before 1978, the duration of those works are contingent upon a few different factors. Now, under both the 1909 and 1976 Acts, works created before 1978, but that were never published or registered with the Copyright Office have protections for life of the author plus 70 years. Also, the 95 and 120 years for anonymous, pseudonymous, or work for hire, it also applies to pre-78 works. But for works published and registered with the Copyright Office before March 1st, 1978, they were given an initial protection of 28 years. But under the 1909 Act, these works are required to adhere to specific formalities to claim these protections. The first being to register the work, which gives you the initial 28 years protection. Also, the option to renew protections at the end of the 28th year, which would extend protections another 28 years. And finally, you must include a proper copyright notice. So those are for things that were created and published before 1978. And I'm just going to give you an example of what a proper copyright notice looks like under the 1909 Act. It needs to include the copyright symbol. You know it well, the C in the circle. The word copyright, or the abbreviation COPR period, which you kind of rarely see, but that it would be valid. The year of the first publication of the work and the name of the copyright owner. So here, copyright 2017, Jane Doe. And I want to point out that failure to either register, renew, or include a copyright notice properly means that those works automatically would go into the public domain. So that is something that is a big focus of how works, published works at the library are identified as being in the public domain, is checking to see if it was published before 1978 in the US, and if it follows these formalities of registration, renewal, and a copyright notice. I don't really have, unfortunately, enough time to get into how a copyright check works for at least the New York Public Library. But I will point out that there is a series of guides called the Catalog of Copyright Entries. These were catalogs that were published yearly by the US Copyright Office. And basically they summarized all the copyright registrations, those little cards that are housed in the Library of Congress. They were published as this catalog. So there's different ways and methods that you can review these catalogs to see if a work was properly registered and renewed. For works following the correct formalities, registration, renewal, proper notice, the copyright duration was modified in the 1976 Act, which extended the renewal term to 47 years, in addition to the 28 years originally allotted with that initial registration. Now, due to additional lobbying by important copyright owners such as Disney, additional changes were passed through the 1998 Extension Act, also known as the Mickey Mouse Act or the Sonny Bono Act, which extended protections for another 20 years. So now, when considering a properly registered work prior to 1978, we are talking 95 years of protections. And this is how we get that cardinal copyright rule that I'm sure many of you heard of, that any work published before 1923 is in the public domain. And that rule did stick for many years, since in the interim between the establishing of the 1998 Act, there was a freeze that was created where no new published works in the US could enter the public domain for about 20 years. It's just basic math that given when this law was established, that 95 years of protection meant anything published before 23 entered the public domain, but there was about a 20-year period where everything still had protections that were created after that time. But I'm happy to report that as of 2019, the 95-year clock is now moving again. And currently, works published in the US before 1927 would be in the public domain. And Mickey Mouse, seen here, smiling all the way to the bank, right now, will change their copyright status in a couple of years, in 2024, when Mickey Mouse will enter the public domain. Nice segue. Speaking of those works, let's talk in detail about the public domain. So we have a basic idea of copyright duration. A work in the public domain is when a creative material is not protected by intellectual property right laws such as copyright, trademark, or patent laws. It's kind of the end of the line for the copyright duration and the beginning of a new life for that creative work in which is free to use for everyone. And that means the public technically owns these works, not an individual or author or artist. Anyone can use a public domain work without obtaining permission. So what are some examples of things that are in the public domain? These include works published in the US before 1927, Unpublished works that follow copyright durations, the life of the author plus 70 years, works that are created by a branch of the US federal government, which are considered to be the property of all US citizens. This would include government-produced documents and even some creative works under things like the Works Progress Administration that was created in the 1930s. But I want to make a distinction here that I'm talking about federally produced and published materials. State-produced materials, like a New York state-produced document, may have copyright protections under state and federal law. Really, the US federal government stuff is the only thing that's considered automatic to the people. Also, things that are in the public domain are things that aren't copyrightable at all, like dates and facts that I talked about earlier. And again, US published works prior to 1978 that failed to comply with the certain formalities I mentioned, failure to renew protections after 28 years of registration, or the non-inclusion of a copyright notice. So one example of a public domain work is the novel The Great Gatsby by F. Scott Fitzgerald. It was first published in the US in 1925, and although the copyright was renewed 28 years after registration and with proper notice, even with those extensions of protections allowed to by the 76 Act and the Sonny Bono Act, the work entered the public domain on January 1st, 2021, since the full term of protections, 95 years, had expired. Another example is the film It's a Wonderful Life, which included a proper notice, but copyright lapsed due to a failure to renew that copyright at the end of 28 years. But I want to mention that it gets a little bit more complicated here because despite the lapsed copyright, television stations and other people that wanted to show the film still had to pay royalties, not because the film's copyright lapsed, but because the underlying story, which was titled The Greatest Gift by Philip Van Doren Stern, was correctly renewed in 1971. So the film, being a derivative work, may be in the public domain, but there still needs to be some copyright licensing done because of that underlying story that still retains proper copyright. I just want to briefly get in the last minute or two, get a little bit into copyright treaties and how we differ as a model than other countries. First off, every country in the world has some sort of copyright law. And with the rise of the internet and instant globalization, this need for intellectual property to be understood and protected is perhaps more important than ever throughout the world. Much like trademark and patent law, copyright in the US sees creative ideas and works, when fixed, to be its own form of property. US copyright law in this way follows an economic model of copyright law, where copyright granted to authors in order that they are appropriately rewarded for their work and therefore appropriately incentivized to provide that work. The laws in other countries may emphasize moral rights in certain areas. A good example is France, which has more restrictions on the transfer of rights to persons other than their creator and includes more requirements of attribution to the original author and objects derogatory attribution to or treatment of the work itself. Now, suffice to say, there is no real international copyright law. However, many governments have signed treaties agreed upon by multiple countries, and these treaties help to harmonize some basic copyright protections globally. There are too many, of course, to get into in one presentation, but I'd like to talk briefly about the Berne Convention for the Protection of Literary and Artistic Works, which was established in 1886 and which the US joined in 1989. Currently, about 179 countries are signed to the convention. Berne lays out some rules for protections that all signatories must follow. That includes national treatment, where works created in one country must be granted the same protections in the other signatories' countries. Automatic protection, which means that no protections can be limited due to formalities. That is going back to why in the 76 Act, we dispelled with the formalities under the 1909 Act that I talked about. And independence, that their protections are independent from those granted within a country of origin. The Berne Convention also has minimum standards and mediums of protection. It outlines some basic criteria for fair use, and it also opens up moral rights for countries such like the US, which really doesn't address at the federal level moral rights. And that's why we have things like the Visual Artists' Rights Act and a few others that address more of attribution and modification of works rather than economic compensation if something is destroyed or infringed upon. I want to thank everyone for listening. And yes, I hope everyone comes back for part 2 and 3. Again, part 2 will get into exceptions in copyright and limitations such as fair use and first sale doctrine. Thanks again.